This is Dr. David Schein, and welcome to Business Law 101. One of the most famous cases is, of course, Palsgraf, decided by the famed Justice Cardozo, Benjamin Cardozo, wrote in the 1920s, 1930s, moved up from the state court system to the federal court system. And what it says is that the defendant, and this is 100 years ago, is only responsible if he could have foreseen the damage that occurs. And as you recall, this is the fellow that had a package of fireworks under his arm, and he catches the commuter train, and the conductor reaches out and helps him grab onto the back of the train. As he catches onto the back of the train, his arm releases the package of fireworks. They explode on the tracks behind him, and the concussion causes one of those old-fashioned scales to drop a weight, and the weight impacts the plaintiff, who was near the weights when they fell. And Justice Cardozo said it would be unfair to hold the defendants liable because they could not have foreseen that helping this gentleman jump on the train as it leaves the station would have caused this accident that caused the concussion, that caused the injury to the plaintiff. Now, what I again want to caution you is 100 years later, very, very likely that decision would have been in the opposite direction. They would have said, well, of course that was careless. They should have made him wait and take the next train. Because he was sloppy and careless, and the railroad was sloppy and careless, this injury was a direct and foreseeable result of that carelessness. So you can see how legal opinions have changed in the last 80 to 90 to 100 years. So keep in mind that malpractice is a very significant area. It's one of the reasons why our health insurance premiums are so high and our doctor bills are so high, because we all are sharing the cost of some of these runaway, what we call med-mal, or medical malpractice cases. In Texas, there's been a significant move to limit med-mal. You cannot file a medical malpractice case unless you have it reviewed before you file it, which is a very significant issue. And then the second one is that it is your damages are limited under our progressive concepts of tort reform. Is there's only so much that you can recover. And of course, since medical doctors are licensed professionals, their benchmark is degree of care in their profession, not the reasonable person standard, which is the general standard for evaluation of tort liability.